Whenever you're ready.
Good afternoon, Your Honors. May it please the Court, I'm Shelley Leineke on behalf of Van Liner. With the Court's permission, I'd like to reserve 5 minutes for rebuttal.
Okay.
We are appealing today from a summary judgment by Judge Pedinow saying that coverage exists and therefore requires defense of Van Liner's insureds, Mr. Hunt and First Class Moving, in an underlying suit that was filed against them by Premier Moving and Storage. Of course, there's de novo review here. Premier had sued Hunt and First Class in an 8-count complaint, 4 counts against each of them. The first count asserted in the style that it was a claim of negligence, but in the body of the count, it said that Hunt and First Class obtained access to Premier's premises without Premier's permission or authority and removed property of Premier without its permission and authority.
Well, I feel like when I read this that I'm missing a piece of this. Somebody had Premier go in, Hunt go in, excuse me.
Apparently the landlord had a fight with Premier,
right.
Premier's landlord, and so the landlord apparently hired Hunt and First Class. Hunt
to go get Premier's stuff out.
To go get property that belonged to someone else who was storing things at Premier's premises.
Okay, well, Premier was in charge of this stuff.
Premier had, I believe it was the Army, it's being alleged, that they were storing Army goods. And so when Hunt and First Class were asked to go in and get the Army's stuff out of Premier's storage facility, without permission, they also took Premier's goods. And Premier's goods, as set forth in the exhibit to Premier's complaint, which we have at page 65 of our appendix, constituted 7,000 warehouse pads or over 7,000 warehouse pads, steel racking, a Caterpillar forklift, 324 four-wheel dollies. It goes on and on with a list of things that are clearly moving and storage equipment that belonged to Premier. So Premier then sues Hunt and First Class saying, wait a minute, you never had permission of anybody to take our stuff. Van Liner, as the carrier for Hunt and First Class, said, well, we're not going to defend you because none of the allegations fall within the policy coverages. There's several policy coverages under the Van Liner policy.
Was negligence one of the policy coverages?
Yes, well, negligence would be, but it's our position that even though this one count is styled as negligence, when you actually read the body of it, it is not alleging anything that would fall within the policy because the so-called 2 negligence counts allege that Premier's property was taken without its permission and without any authority, and it was removed without any authority. So therefore, that is not negligence. That is removing something. There's no offer and acceptance. The liability as a warehouseman applies where there is loss or destruction of goods which have been accepted for storage or accepted for preparation for shipment at the premises of the insured. In other words, if someone's goods are at Hunt and First Class's premises, either to be stored or to be prepared for shipment, that would fall under warehouseman's liability. And this is at page 823 is where we have the coverages. This also does not fall under coverage B, which is liability of a carrier, because that is for the transport of goods of customers. And there's no way that Premier is a customer of First Class and Hunt. There's no contract there. There's no arrangement there between them. Hunt and First Class have an agreement with Premier's landlords to take the Army's equipment or stuff or storage out, but nobody has an agreement to transport any of the equipment of Premier. So therefore, under those 2 coverages, it doesn't fall under either of those coverages, no matter what the count is styled. And it can't fall under any of the other coverages. For example, coverage C is uncollectible charges of the insured. Well, that clearly is not applicable. Coverage D talks about customers of the insured who have obtain some insurance on their goods. Well, and it's for household goods. Well, clearly, these are not household goods. The allegations of the complaint shows we're talking about 7,000 moving pads, we're talking about forklifts, we're talking about container storages. A, that is not household goods, and B, there was never any policy taken out to insure those.
Just to understand, the location is relevant as well as whether there was negligence.
Correct.
It doesn't matter what the body of the negligence labeled count says, because the location wouldn't have been covered. Is that correct?
Correct.
But if there was negligence in their own location, then you'd have coverage, but there's no allegations it's kind of a round peg in a square hole. They don't fit together.
Correct.
On the face of the pleadings.
On the face of the pleadings, yes.
And what was Judge Pedinow's logic?
Quite frankly, I'm not sure I could announce what his logic was.
Coverage,
he just simply
duty
said...
Duty to defend is broader than coverage, that generic application?
He just, my recollection of the transcript is he listened to both sides' arguments. There were counter or cross motions, and he just said, I'm finding there's coverage.
You didn't bring a Venn diagram?
Without giving...
We need a Venn diagram on this one, I think.
No, he did not give us a diagram on that. And previously, we had tried to take some discovery. And Judge Pedinow said, no, there's no reason to have any discovery because the four corners of the complaint control whether there is a duty to defend, so therefore you don't need to ask any questions, which led to our argument that...
That didn't prejudice you, if you're correct on the legal analysis.
Certainly not on duty to defend, although there's been apparently some controversy developed as to whether there is a request for indemnification as well. There had been a stipulation below that the plaintiff was only, Hunt and First Class were only seeking defense and not indemnity. So the indemnity, I take it that there is an agreement that there is no obligation to indemnify at any point on this. The parties agree on what the rules of law are here that govern insurance policies in terms of looking at all the conditions, enforcing the policy as written. Even if you need to have some interpretation, that doesn't mean there's an ambiguity, and that you're supposed to use the common meaning of words, and that it's the insured's obligation to establish that a claim falls within the scope of coverage. As I understand the argument raised by Hunt and First Class, they are saying that, well, there is potential liability because where goods have been accepted for preparation or shipment, the plain meaning of shipment also includes transfer. And somewhere along the line, Premier's property was lost supposedly during the process of transfer from one facility to another. Well, with due respect, that is not what is either alleged or what is covered under the policy. Again, warehouseman's policy coverage, which is coverage A, requires the damage to occur at the insured's premises. It has to occur on the premises of Hunt and First Class. And it has to either be goods that were accepted for storage or goods that were accepted for preparation for shipment. There can be no acceptance of the goods of Premier when there's never any contract or any offer of those goods. Again, these goods are taken without permission or without authority according to the plain language of the complaint. Nor can there be coverage under the liability as a carrier because damage that occurs in transport requires damages to goods of a customer, and at no point was Premier ever a customer of Hunt and First Class. Again, Premier's landlord was the one that said, go take the Army's goods out of Premier's premises. There was no agreement or arrangement or customer relationship with Premier for the transfer of their goods.
And could you direct me to that in the policy?
I'm sorry.
I know this, I think this microphone is, where in the policy does it indicate? I want to be able to look at the policy regarding this goods destroyed in transit. Could you direct me to that?
Page 23 of our appendix, which is page 1 of 13 of the description of coverage and insuring conditions. Right. There are 5 types of coverage that are described there. Coverage A is liability of a warehouseman, and that says in paragraph 1, in roughly the middle of the page, that it talks about damages whether imposed by law or assumed by the insured under a contract for storage because of physical loss, destruction, or damage to goods of others that have been accepted for storage or for preparation for shipment occurring at the premises specified in Section A, which is, of course, the premises of the named insured Hunt and First Class. Coverage B, which is liability of a carrier. So coverage A says if I've got your goods in my warehouse and I'm either holding them for you or I'm wrapping them up so they can be shipped and something happens to them while they're in my warehouse, me now being Hunt and First Class, that's covered. Coverage B, liability as a carrier, says that there is coverage where the goods are under contract for transport because of physical loss, destruction, or damage to goods of customers of the insured. So if you have a contract to move a customer's goods from point A to point B, and they're damaged in transit, there's coverage there. So coverage A is I'm storing your goods or I'm wrapping them up, and if there's something that happens at my warehouse, there's coverage. Coverage B is if I'm driving your goods from point A to point B, and you are my customer, then there's coverage.
Okay, and that's what I'm trying to find out about. Where does it say that if you are my customer? Direct
Well,
me to that.
it says very specifically, the second line from the bottom of coverage B, it says loss, destruction, or damage to goods of customers of the insured.
We're looking at coverage B, correct?
Correct. Coverage B.
Oh, I see. Okay.
On the bottom, the third line talks about physical loss. The third line from the bottom says physical loss, destruction, or damage to, and then the second line from the bottom says goods of customers of the insured.
All right.
So there's no question that Hunt and First Class were never a customer. Again, the landlord was the one that hired Hunt and First Class to move the goods of someone entirely different, the Army. So there's no customer relationship there. I really don't know that there's more that needs to be said on this. Coverage D, again, cannot apply because there was no insurance policy taken out for any goods that might be damaged, and that specifically also requires household goods in coverage D, and there's no question, since exhibits that are attached to a complaint control over contrary allegations, the complaint of Premier on page 65 of our appendix outlines all of these things are moving equipment. These are not household goods. 50 aluminum decking bars, 15 overseas containers, Caterpillar forklift, 500 storage vaults, 7,000 warehouse pads. Things of that sort are certainly not household goods. And then coverage E, which is moving equipment, is talking about moving equipment that is owned by Hunt or First Class. So if Hunt and First Class have their moving equipment, including their dollies or pads or burlaps or things of that sort, if that's lost or damaged, then there's coverage. It doesn't cover moving equipment owned by some other moving company. So under the plain policy construction rules, the plain meaning of law, the allegations that are set out in the complaint, we believe Judge Pedinow erred in granting summary judgment, determining that there was an obligation to provide a defense to Hunt and First Class. We would ask for this case to be remanded back for instructions to enter a summary judgment in favor of my client. And one other very quick point, if I may. There was a reference made in the answer brief to Florida Statute 627.426, which is the statute that says that an insurance company has 30 days where it knows of a coverage defense to give notice. These are not coverage defenses. These are policy defenses. Coverage defenses, as explained in the Block versus AIU marine insurance case, coverage defenses are where nobody questions that coverage applies, but the insured does something like late notice or fails to cooperate that raises a defense to coverage that otherwise exists. Policy defenses, whether something is outside the scope of coverage, for example, It's an auto accident and you're suing under someone's homeowner's coverage. That's outside the policy. There's an incident that falls within an intentional tort. That's an exclusion under the policy. Those are policy defenses. Those do not fall within this requirement of giving the 30 days notice. We believe we did timely give notice, but in any event, that statute does not apply. There's no question that 3 of the 4 counts plainly are not something that would have coverage because they're conversion or other intentional torts. But even the negligence count, when you look at what is actually alleged in the count that is titled negligence, it falls outside of the coverage that is afforded under the policy. Thank you.
Thank you.
May it please the court. Good afternoon. My name is Tracy Gunn. I represent the appellees in this case, Hunt and First Class Moving Systems. I think that I can make the case a little simpler for the court by telling you that we're not seeking, and no one ever argued, coverage under coverages B, C, D, or E. This is a coverage A case. It's the only part of the coverage that anybody argued. The significance of that is that this customer requirement does not appear in coverage A. And we know because it appears in coverage B and D that if van liner meant for that to be a requirement, that would be in there. It's not in there. There are a couple of issues that were raised in the reply brief in here that I don't see in the trial court or the initial brief. One of those is a big one. It's this at the insured premises issue. And believe me, I looked for it because I think that's a good argument for them. But I'm looking at their motion for summary judgment, page 316 of the record, and their initial brief, and the transcript of the summary judgment hearing. And I don't see any reference to at the insured premises. In fact, the quote of coverage A in everything they filed stops before that part of the policy language. So we would ask the court to just focus on the arguments that were raised both below and in the initial brief as required to preserve them. Obviously, the insuring agreement being triggered is an issue that is normally at the inception of the case, the insured or claimant's burden of proof. But once they're the appellant in the case, it's our position that they had an obligation to raise those issues below and to bring them up, at least in the initial brief. And what those issues were a couple elements of the insuring agreement. The main argument was this can't be negligence, even if you call it negligence. We admit negligence is covered, but this isn't really negligence because you didn't have permission to take our stuff. Now, Judge Kelly, you said something that made me think about this underlying complaint differently than I'd ever thought about it before. Because what you said is someone told them to come in and take the stuff that Premier had out of there. I don't think that's alleged in the underlying complaint. I think what the underlying complaint alleges is Premier had stuff in the storage facility. That stuff included their stuff and their third-party customer stuff. They got in a dispute with the landlord. They were locked out. 2 months later, someone gives permission to Hunt and First Class to come in and take other people's stuff. This may or may not be the same stuff that Premier had custody of for its customers. That's not alleged in here, and I never really took it that way. It may be that way, it may be not that way. I'm not sure it matters. What matters...
Well, I was guessing, because there's a giant hole in the facts.
Which is what? Which is an ambiguity, which means you interpret it in favor of at least a duty to defend, which is what we're here on. And I do want to address this indemnity versus defense issue because this is an outright denial case, meaning that Van Liner completely denied a defense. The only counts in the declaratory judgment and breach of contract case that we brought were for the duty to defend. That's true. That doesn't mean we're saying there's no coverage under the policy. What we're saying is that if you breach the duty to defend and you owed it, you're paying that as damages for breach of the duty to defend. We don't really have to prove indemnity. So there's no real splitting causes of action issue that the court has to reach. We did argue that the indemnity issue wouldn't have been ripe yet anyway, but I don't think the court needs to reach that. But it certainly doesn't preclude us from arguing that there's no duty to defend because that duty would be broader. Getting back to the underlying complaint, this is called a negligence count. There is something called a negligence count against both defendants. Both defendants are insured. The negligence count says you were given permission to enter the property. You didn't break and enter. You didn't steal everybody's stuff. You came in with a contract to take certain things. You accidentally or intentionally, we don't know which, took other people's things along with that. It says that. Hunt did not have permission to remove plaintiff's personal property along with the third-party owned property. The allegation is they had permission to take the third-party property. Whether it's the same property that Premier had, who knows? I don't think that matters. They did have the right to enter the premises. They lawfully entered. They took the wrong stuff. And then the allegation is once you took our stuff, you had a duty of care to maintain it properly. You failed in that duty. There was a breach, there was causation, there was damages. It's a classic negligence count. And so the argument below was this isn't really negligence because they stole it because they didn't have our permission to take it. There was no case cited then or now that says if you take something by accident without permission, even though you have permission to take these things here, if you also take these things here, that's somehow by definition not negligence and not covered under this type of policy. The other argument that was made and emphasized a lot in the initial brief was this contract for storage. I didn't see it in the reply brief, I didn't really hear it discussed here, but I think that we established in the answer brief that there doesn't have to be a contract for storage to trigger coverage A. It's either an obligation under liability under the law or a contract for storage. This negligence count creates liability under the law and therefore a duty to defend. Likewise, an argument that was made below in the initial brief is that there was no acceptance for storage. And it's just a question of, is this court going to read into that in coverage A a requirement of an offer and acceptance, or just what the plain language of the policy says, which is acceptance, which is you took it. And they did. That's what the allegation is. Again, the customer issue, I don't see raised anywhere in the initial brief, but I think it actually helps us because that requirement doesn't appear in the coverage part that we are proceeding under, which is coverage A. And if it was a requirement, it would be there. The reply brief also identifies these items in Appendix A to the underlying complaint, what was taken. It's not just moving equipment. It's computers, it's business equipment.